immigration updates every Tuesday. Live Q&A is for the 1 hour period, 5 p.m. to 6 p.m. Central Time, live from Houston, Texas. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Well, today the Senate passed their version of President Trump's one big beautiful bill to pass a budget. So now we are back in the House for them to finally pass the bill. So we're going to talk about how this particular bill impacts legal non-immigrants. We're also going to talk about the new data that came out from USCIS. There's a lot of different data that they put out every so often, but we have updates on EB2 and EB3, India wait times, how many 485s are pending, how many people are in the backlog, how many people are in the EB1 category, what's the new wait time we can predict as best we can with the visa bulletin. We always say that we're some of the worst people at predicting the visa bulletin, but we always get asked to do it anyway. So we're going to give it a go today and let you know what we think will happen. We're also still seeing some fallout from these SEVIS terminations for F1 students. We're still seeing more RFEs on OPT and STEM OPT applications where they're stating they did some sort of criminal records check and found that there was a violation somewhere of traffic violation. Some of them are more serious DUIs or shoplifting or that sort of thing, but they're basically bringing this up in the 765 application with potentially plans to deny the application under their discretion. So we'll talk about how to deal with those types of RFEs and requests. And then lastly, the Birthright Citizenship Executive Order. We had some action in the Supreme Court late last week. So we'll talk about what that did and where we stand as of today and what we should look for going forward.
Definitely in the Senate bill with regards to one beautiful bill, it's about the finance bill, nothing much about the immigration. So not especially for the legal immigrants though, doesn't seems to be much major things of concerns, but there are some concerns definitely. A lot of money is allocated for the immigration and enforcement, not to the USCIS, but Immigration, Customs, and Enforcement. So what will happen is that this is going to put a lot more pressure on vetting process where there will be more delays in adjudicating the applications, probably when you're entering into the port of entry. Also, when you're trying to change the status, there may be some enforcement where there may be more FDNS visits, more scrutiny on the OPT, more scrutiny on the STEM extension. Definitely not good for the business immigration, for the people who wants to legally stay and work in United States. It's not a good thing for them. And
Yeah, go ahead.
Right, you go ahead.
I was just going to mention the remittances tax. So, in the House version of the bill, it was originally planned for a 5% tax on any money non citizens are sending home. That is now reduced down to 3.5%, which is still a major tax. But better than it was. We still have to go through the House to finalize the bill. President Trump has given a deadline of July 4th for that. It's not a real deadline. It's just he would like to see it on his desk by then. There's some Republicans in the House that aren't very happy with the Senate modifications that were made. So we'll have to see how it all shakes out. But for the most part, for legal immigrants, not a lot of impact, as you mentioned, other than due to higher levels of enforcement funding, we can expect to see more enforcement happening, more scrutiny of everything as they spend those funds.
I see some bond of $250 if they don't depart within a certain period of time that has been allocated. I don't think so. That's something that a lot of the non-immigrant visa people will be concerned about. The legal immigrant people will comply with it. I'm not expecting much problem from on that part, Emily. There are some fees increase with regards to the diversity visas. We've also seen some increase of fees in the court when we try to file the 485 application for some of the people, and also appeal. If we appeal any of the decisions, the fees has gone up for those people who are visiting on ESTA.
which is the visa waiver program. They have started charging some fees according to this bill, but not much major changes. Even though they look to be
Some when it is effective to the people, though, when as far as the non-immigrants are concerned, I don't see much negative effect for the people who wants to stay legally in United States. Emily.
Yeah, I agree. I mean, it is ultimately a budget bill. We've seen a number of times over the years where different powers in Congress try to pass things that are beyond budget, particularly immigration provisions, and usually the parliamentarian and the Senate shoots those down. That happened again this time. They were trying to do a lot of things with Medicaid and Medicare with, not allowing undocumented immigrants to access those services. All of that was kicked out of the bill. So we've kind of got a little bit watered down version of compared to what we had before, but as you said, not a lot of impact to legal non-immigrants.
With regards to the remittances abroad, though, it seems that there is some discrepancies between the House and the Senate. Between 3.5 and 1% is the debate that's going on. We will come to know because the Senate version has been passed. It will go to the House, and after that, it may come back to Senate for any minor changes. Then it will be finalized. But yes, that is right, Pranav. It is between 1% and 3.5%. They're debating at this point of time. Anything else, Emily, before we go to the next one?
I think we can move on to the next topic, the EB2 and EB3 timeline, now that we have the current number of pending I-485s as well as the current number of approved I-140s where people are waiting for their priority date to become current. So this is posted periodically on the USCIS website. There's two different um, spreadsheets that they post. One of them is the pending applications for employment-based preference categories. That's basically the I-485 inventory report. That tells us how many 485s have already been filed and are still pending, either waiting for the priority date to become current under the final action date, or just waiting to be processed due to processing times or RFEs or that sort of thing. And then we also have the Form I-140 approved EB petitions awaiting visa final priority dates, also updated. So in terms of the number of 485, so we hadn't got these numbers in a while. We were able to get some numbers back in, I think, 2022 when we were dealing with some lawsuits due to retrogression that was happening at the end of the fiscal year. And based on the number of 485s in the inventory at that time, we were kind of thinking that it would be several years before the visa bulletin cutoff dates moved back to where they were in October 2020. We were kind of predicting maybe around 2030, but it looks like it might be longer than that even. So right now, already at USCIS today, there are still 48,000 I-485s pending in either the EB2 or the EB3 category for country of birth, India. Now, we combine EB2 and EB3 together because if you have an EB2, you can also get an EB3 pretty easily. So a lot of people switch back and forth. They have both. And we also look at the number of green cards that can be issued every year in those two categories and combine them. So we have our 28% of the 140,000 employment-based green cards, assuming there's no spillover from family-based in prior years. So that gets us about 40,000 EB2 green cards, 40,000 EB3 green cards every year available. Then we have to implement the 7% cap, which reduces it down to 2,800. So basically each year, EB2 and EB3 India maximum can get around 5,600 green cards. Again, assuming that there's no spillover from family based, which still had a little bit this year, but that's not likely to continue for any long term. So we're talking 48,000 pending 485s, and we can only approve 5,600 per year. It's going to take about 8 years to get through all of those. That puts us into 2033. That will basically move the visa bulletin priority date cutoff back to where it was in 2020, which would be up to through 2014, so around January 2015. So by the time the priority date moves to January 2015, we're going to be into the year 2033 if nothing changes. So that is definitely not good to see. If we're talking about, the dates feel like they're stuck in 2013, that's because there are still 17,000 485s pending with 2013 priority dates. And again, if they can only approve 5,600 per year, it's going to take 3 years just to get through the 2013 priority date cases. We are in 2025. So this is a ridiculous backlog that's just growing more and more. Beyond that, once we get through 2013, to get through April of 2014, just to move a couple, 3-4 months, it's going to take a year. So every year we might move forward 3 months at a time. So it's just crawling forward. And then EB1 currently has 15,000 cases pending for country of birth, India, and those all have a priority date before 2023. Now, EB1 also gets the 40,000, and then we have the 7% cap, which brings it down to 2,800. However, because rest of world does not always use up all of the EB1 green cards, a lot of that spills across to India. So where generally year after year, India gets close to about 10,000 EB1 green cards. So if there's 15,000 pending already, it's going to take us a year and a half to get through just what's in the inventory before we can move forward. So we're probably looking at a consistent 4-year wait for EB1, not counting people who retain a priority date from EB2 or EB3 and bump up into EB1 through the extraordinary ability category, or maybe work abroad for a year and come back and qualify for EB1C.
So practically, Emily, what you're telling is that by the time the priority date moves to 2014, because they have to complete the 2013 485 applications, it might take 3 to 4 years for them at least to complete. And by the time it goes to January of 2015, which used to be January 1st, 2015 was the priority date in 2020. By the time it goes there, it might take up to 2033. That is a very long time. So practically, I tell people who have been waiting for a long period of time, unless they have some other qualification to get to EB1, then you probably have to give up hope on the green card, though, because that's a very long period of time. I still don't want people to go into this. A lot of fraudulent people have come up right now to fake the awards and to fake the publications, and they're doing the publications, writing awards and everything, as long as you pay the money. And we have seen a lot of kickback from the USCIS right now. And if they find out, which they're finding out right now, they will revoke your H-1B, they will revoke your previous I-140, and they will get you back, because once you have intentionally committed any fraudulent activity on USCIS, you will not be allowed to ever come back into the United States, which we are seeing in some of the places right now. So definitely we recommend people not to go into these agencies to get it. If you are really genuinely qualified for EB1A, that's a completely entirely different story. You should try to get an EB1A approval. With Birthright citizenship updates on July 1st, that's as of today. There are a lot of people who are asking questions. We have put a Q&A. I've updated it again on July 1st with any of the recent changes that have happened. We have put we are collecting the information with regards to the people who are on whose children are going to be born after July 27th. There is a MailChimp. That means that you enroll in this one. We are going to conduct, Stephen Brown from our office is going to conduct periodic Zoom calls exclusively for these people. Because then we are not going to address anything else in those Zoom calls. Only the people whose children are going to be born after July 27th. That MailChimp link is been provided at the bottom of this video. We want you guys to subscribe to this and so that we can give the information, and we will invite you for the Zoom calls where people can attend, and that will be exclusively only for the people whose children will be born on or after July 27th. Right now, the situation is still the same. Nothing has been changed. As you know, that in Maryland court, it was been requested to certify as a class that all the people whose children will be born in United States who do not have the parents do not have a green card should be certified as one class in such way that the court can give judgment on that one. It seems that the hearing of the class on the class to classify as a class seems to be next week. But Stephen Brown is going to update soon. We may come up with another YouTube live on that, or probably do Zoom call for the interested people soon as we are collecting the information. Anything else, Emily, on the citizenship?
Yeah, so just for people to, feel confident, for children that were born between February 9th of this year, 19th of this year, and July 27th, the executive order ending birthright citizenship does not impact their citizenship. Those children are still protected. The order didn't take effect until February 19th, and then there was an injunction that protected those kids, that is still in place until July 27th. On top of that, we do expect more action to happen certainly before July 27th. We might see new injunctions in place, new temporary restraining orders in place as the plaintiffs that are bringing these lawsuits pivot their plans and pivot their strategy in order to align with the Supreme Court's most recent decision. So again, that Supreme Court decision had nothing to do with the actual executive order. It was just determining whether the nationwide injunction was lawful or not. So we will still see high chances of this being put on hold again until we get a final decision on the actual executive order. And that will likely weave its way through multiple levels of the court until the Supreme Court eventually takes it up. So we're nowhere near the end on this, but for now, kids that are being born are protected.
Emily, the SEVIS termination people who got terminated, we thought everybody is safe, is right? I mean, we fought in the court and everybody's SEVIS was being put back in place. Are they
Yeah,
safe
so
right
we're
now?
starting to see, we're starting to see a different way that the government is, looking into students. So they initially try to just terminate their SEVIS records, which ultimately would have put them out of status and had them leave the country. They didn't win on that. So now for those students that do have some sort of run-in with the law, and are now filing their I-765 for OPT or STEM OPT extension, we're starting to see requests for evidence or notice of intent to deny stating that we've done a criminal records check, your name came up, there's some information about you, derogatory information. We think that you've committed a crime or done something. You need to submit to us all of the court records, all of the arrest report, what's going on with the case. And on top of that, they point out now in these RFEs or in these notice of intent to deny that the criminal issue could be grounds for them to actually deny the I-765 application in their discretion. So every single EAD that is being filed, USCIS claims that it has discretion to approve or deny it. So even if you meet all of the eligibility requirements for that EAD, if USCIS thinks that you don't deserve it, they could deny it if they have a valid reason for that. And so they have a series of factors, of positive factors and negative factors. One of the negative factors is the criminal history. And so they're saying, because you have this negative criminal factor, prove to us that you have other positive factors that we should use in our discretion to still approve your application under the totality of the circumstances. So if you're in that situation and you need to provide proof of your positive discretionary factors, you would want to show proof of your academic performance, like your transcripts, honors, awards that you've received while being a student here. Any efforts at rehabilitating yourself? Did you have to go through community service? Did you have to take a counseling program? Any other corrective measures that you've taken? Showing your community involvement, letters of recommendation, volunteer work, participation in community organizations, employment records, if you were lawfully working under CPT or OPT, proof of that employment and what it's contributing to the United States, and then a personal statement explaining what happened, why, and what steps you've taken to avoid any kind of future criminal interaction. By providing all of that, plus the criminal documents that they request, you should be able to sway them that the positive factors greatly outweigh this one negative factor to still get your OPT approved.
Let's go to question assembly. There are a couple of questions. First question is from Lakshmi from Facebook. She has this question that her husband is on H1B, her child is on H4. H1B extension has been approved. H4 extension is still pending. If the husband travels to India only to visit India and come back, will it impact negatively on the H4 extension of the child? Absolutely not. If your husband travels only to visit India and comes back, absolutely not a problem. If your husband travels and stays there and does not come back, definitely it will impact the H4. The only reason H4 is being given is to accompany the main applicant. Since your husband is just visiting India, absolutely not a problem to get the H4 approval.
Krishna says, I traveled to Cancun last year with an expired visa stamp, so used automatic visa revalidation to return. And now he's planning to do it again with his spouse this time so that she can get her I-94 extended. I'm assuming for H4 EAD purposes to qualify for the auto extension there. So he wants to know if there's any issues in using automatic visa revalidation multiple times and any recommendations regarding a port of entry. So there are no limits on your ability to use automatic visa revalidation as long as you meet the criteria for it every time, which is trips to only Canada or Mexico. It has to be for less than 30 days. You don't apply for visa stamping while you're there, and you have a valid I-94 to return back to. You meet those qualifications, and your purpose in Mexico is to visit. You're coming back into the US to work for your employer and for your spouse to join you. Those meet all of the requirements, so should not have any issues for automatic visa revalidations. As far as port of entries, we recommend traveling by air and coming back, obviously by air. We see that because you're traveling by air, they have to give a new I-94, and we would recommend staying there for a weekend, make it a meaningful exit out of the US for a vacation purpose, come back into the US. Those are all things that are going to increase your chance, but we're not really seeing any issues with people using this still to get the extended I-94 to qualify for the H4 EAD extension.
Param asks this question. He has an I-140 approval under EB2 as a software architect, and now he's been an IT manager right now, managing a lot of people. Can he file a EB1C, or does he have to go outside the country, work for the same company, and come back to qualify for the EB1C? For the EB1C, Param, you have to work for the foreign affiliate for at least 1 year. So if you're working for this company for 10 years and you have moved from architect position to, for example, software architect to a high-level IT manager managing 15, 20 people, it is not enough for you to file a EB1C application. You have to go outside the country, work for 1 year, come back, and then you will be able to file the EB1C. Jigar has this question. Have you seen any problem in people traveling on AP advanced parole? Absolutely no problem for the people who are traveling on advanced parole. Pranav has this question. Have you seen any problems in people changing the status from H1B to B2, especially after archiving the B2 information where the USCIS has put it in March 2023 that people can move to B2 and switch back to H1B? No, we have not seen any problem. We have seen recent approvals in the past 1 week. We have seen approvals in B2. We didn't notice any denials or any extra RFEs for the people who are moving from H-1B to B2.
Zoref says, how much time do we have to respond to an I-140 RFE if it's under premium processing? It's been 57 days for me, and my employer is still working with the attorney on it. So it's typically 84 days for a regular RFE, whether it's premium processing or regular processing, it's the same time frame. If it's a notice of intent to deny, annoyed rather than an RFE, then it's only 30 days for the response.
Nikita has this question. She's filed an OPT STEM extension and she received an RFE for the biometrics. And they want the copy of the ASC stamping. That means she has done the biometrics in responding to the RFE. Can she respond to it online? Since she filed the application online, absolutely, you can respond to online. Not a problem at all. Is it common to be called for the biometrics? No, it's not. There is a good chance that there might be some criminal record on you because of which they have called you for biometrics. It could be possible that there may not be any criminal record, but 99% of the time there may be a criminal record on you. That's the reason why they called. It could be a simple arrest warrant because you didn't pay a traffic ticket. It could be any major things, but there seems to be a criminal record for you. That's the reason why they call you for biometric for STEM extension.
Sampath says he had an H-1B, H-4, and H-4 EAD approved with an employer A, and then he transferred to employer B. He only filed the H-1B and the H-4 and got those approved until 2028. The first employer has gone back and withdrawn the approved H-1B since he left the company. And so the online case status shows that the case was automatically revoked as a result of the withdrawal, which is perfectly normal. That's what the company is supposed to do. He wants to know, is the H-4 EAD still valid, or does he need to file the 765 again? Because when he filed the transfer, he did not include a new H-4 EAD at that time. And the good answer is yes, it's still valid. As long as you're maintaining H-1B status with some company, your wife is therefore maintaining H-4 status and she has a valid I-94, that I-765 approval remains valid and she can continue to use that EAD to work.
Saurabh is asking this question, how come nobody is doing anything about EB2, EBT priority date? Well, we have done a lot of activity, especially in the previous administration, and we have been done a lot of activity starting in 1997. I mean, there are a lot of activities that have been done, though. Why we are not doing right now? Because this administration is not going to be good with us. We know absolutely they're not going to be good with us. There are a lot of disagreement among the immigration lawyers. Yeah, for example, how the Supreme Court may rule or may not rule. But one thing every immigration lawyer agrees is that this administration is not going to favor immigrants at all. So if you're going to ask anything, if you're not going to get anything, why waste our time on this? Yes, we did a lot of efforts in the previous administration not to count the family members, use the unused green cards that are available, remove the per country quota limit in the Congress. We tried all those things previously, but right now we're not trying to do anything because this administration or this Congress is not going to do anything anyway.
TechBurst says, how long is it taking for an H-1B change of status to H-4 and H-4 EAD? And is it possible to have a gap between the H-4 approval and the EAD approval? It's all over the place in these processing times. I would plan on at least 6 months right now, probably even closer to 8 months. If you are filing standalone without an H-1B along with the H-4 and H-4 EAD. It is possible to see a gap, meaning that your H-4 change of status gets approved. Now you're in H-4 status, but your EAD is still pending. In that situation, you do have to stop working because you're in H-4 status without a valid EAD. It happens. It does not happen in every case. It is still relatively rare. Most of the time they are approved together. The times where they're not approved together, it's often because something was missed in the EAD application and they have to send an RFE asking for whatever that missing document is. So it's always important to make sure that everything is properly filed in both of those applications. Now, sometimes you do properly file everything and the officer misses, or a document disappears in the mailroom in the scanning process, or they lose your photos. And so even though you did everything right, you might still get an RFE for a missing document. That does happen as well, but it's still a relatively small percentage.
This question is coming from Chris, and we have noticed a lot of questions coming on our daily conference call that we have free. People can attend it. It's half an hour. It's going to be interactive. The link is provided there. Every single day from past 13 years, Reddy Neumann Brown has been providing free conference call. You can attend it. This question is coming up very common, Emily, is that there is a rumor that a lot of YouTubers now are coming in and saying that if you travel outside the country and say stay 60 days outside the country, this H-1B guy was coming back into the country and they deported that guy. Absolutely a lie, 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 lie. Absolutely not true in there. We have offered free consultation to that guy. One guy comes, my cousin is being deported. Why can't I speak with your cousin? I will do a free appointment for that guy. I offered him. Nobody took the bait. Nobody. There are information guys. If somebody is deported, there may be some other reason. They may have some criminal record. There may not be a job. That is the reason why they get deported. If somebody, let's say if you're working for ABC consulting company and you have a job, you go to India, you stay there for 60 days and you come back after 60 days, you still have a job. Okay. And when you're coming into United States, you will have no problem coming back into United States. Now, here's the point. When you're coming back into the country, the job should still exist. If the job is not there, then they may deny your entry, because the only reason why you're coming on H-1B into United States is to do the job. If the job is not there, they may deny your entry. But if you stayed outside the country, let's say 70 days, you still have a job. And some of the people work remotely from India. That's perfectly allowed. And you're coming back into United States, you still have a job. They did not deny the entry. That is a big lie that has been propagated by some people. I don't know why they're doing it. It is not true.
Astro says, I got my H-1B extended recently, and then my company was acquired. Should I amend the H-1B to the new company, or can I keep the current one for the next 3 years? I have a visa stamping appointment in December. So assuming that the new company that acquired the old company is qualifying as a successor in interest, there is no need to amend the H-1B to change the company name. You don't need to file a transfer. You don't need to do a new LCA. It is a successor in interest, which means that the new company takes on all of the immigration responsibilities of the old company, and they are now your sponsor. Now, when you're going for stamping, I do recommend that you carry an employment verification letter from the new company that also details the acquisition and confirms that they are the successor in interest, and it asks the Department of State to issue the visa, even though the old company name is on the I-797 approval notice. Done that many, many times over the years, never had an issue so far.
Pri from YouTube has a very genuine question. His baby is due on July 20th. What are the chances of a US citizen? Wife, of course, is an H4, and he's an H1B. Government is maintaining the position anyone born after February 20th is subject to the executive order. You're right. The government is arguing that anybody born after the executive order effective date, which is February 19th or February 20th, after February 20th, that's what the government. But courts have granted the injunction at this point of time, that executive order is not is put on hold until the decision comes from the Supreme Court. Um, it would be very unlikely that the Supreme Court will will agree completely with the administration on that. Even if they do agree, though, they most probably will agree from the time the Supreme Court gives a judgment, is what I am thinking, Emily. What do you think so?
Sorry, you're gonna have to repeat the question. I was reading.
Now, it's about the US citizenship. If the child is born on March 1st, will that be a US citizen? Because the government is telling they're not. I'm thinking that the Supreme Court probably will give a decision, even if they don't give a decision even if they support the executive order, though. I'm still believing that the people who have born in up to July 27th of 2025 should be getting a citizenship. That's what my belief is.
Yeah, I agree with you on that. Absolutely.
And of course, you're reading the questions. Um,
All right. Ashok wanted to know about age out children. So he's on H-1B. Children are now in college and they'll be graduating in 3 years and will have to move to F1. They've been living here for the last 13 years. He wants to know, is there going to be a bill or something that allows them to have an EAD or any kind of relief for these age out children? So there have been various bills over the years that have included provisions for age out kids. Um, One of them was including DACA kids as well. It's a much bigger bill that had provisions in it. It is not moving forward in the current environment, probably unlikely to pass during the next 2 years at least. We'll have to see if um, what happens during the midterm elections, if we have a change there. There is a group that's doing a really good job at advocating for these kids, and it's called Improve the Dream. I would definitely recommend that your kids join up with them and find out how they can reach out to their congressman, reach out to their senator to support bills that will do something and provide some kind of relief for these kids who've, lived here most of their lives and are just left out of the process, even though they've done everything correctly.
Mir Akbar is asking the question, can I apply for I-140? I'm on CPT right now. Absolutely, you can. No problem with it. Gayatri from YouTube is asking the question, I have filed H-1B. It's been 3 weeks. It's pending. Can I now convert it to premium processing? Absolutely, you can.
Jugal says, is the original I-797 needed for the consulate visa interview or at the port of entry? I have the black and white copy, but the original got lost in the mail. So consulates generally don't need the original. They do have access to verify approval in their PIMS system. So you have not needed to take an original with you for visa stamping. However, ports of entry are another story. So I do recommend people carry the original with them at the port of entry to avoid delays or avoid secondary inspection during that part of the process. So you may want to file the I-824 application to get a duplicate approval notice issued before you exit the US.
Shiva has this question, is every traffic ticket is going to be a problem for the H-1B extension or the adjustment of status? No. The regular traffic ticket, like speeding tickets and certain things, they are not a problem. Definitely, if it's a DUI, you definitely need to consult a lawyer privately, though. Now, there are some cases where the regular traffic tickets have got into trouble, though. Those instances are only when you don't pay the ticket or when you don't attend the court hearing. When people challenge the speeding ticket by going to court or by hiring a lawyer, which is fine. I mean, I don't see any problem in it. As long as either you pay the ticket or you challenge it in the court and then get the result and you pay later on, or the case gets dismissed, it's absolutely not a problem for speeding ticket. It's only that when the speeding ticket has been issued and you don't pay the speeding ticket and you let it pass, that's when it will become an arrest. That have created some problems for the people who are on F1 visa, that have created problem for the people who are on H1, H4 EAD, and other people. We have seen some problems for those people where they have been called for the biometrics. And as for some people, the SEVIS has been terminated, which later has been reinstated. But if just you got the speeding ticket, you just paid the speeding ticket, absolutely will not cause any problem for your H1B, will not cause any problem for your adjustment of status, will not cause any problem for your I-140, will not cause any problem when you go for stamping.
Chinton says, considering that AI is getting more powerful, how does the H-1B even remain relevant in the coming days? How do you justify to USCIS that an individual's skills are not found in the US when there's so many layoffs happening? It's an interesting question. Um, the thing to be aware of with the H-1B is there's no requirement for a company to prove that the skill is not found in the USA. The only thing that the company has to prove is that the job normally requires a bachelor's degree and that the person they're wanting to hire on the H-1B has a bachelor's degree. Now, the company cannot go and lay off a bunch of US workers and then turn around and bring in foreign workers on H-1B for those exact same jobs. That would be a violation of that labor condition application and the LCA regulations. But but we're not in that kind of situation. The H-1B is still useful, regardless of whether a skill is found or not. That's not really a part of the adjudication process. That's how it was designed by Congress. If that's going to be changed, Congress has to change and redefine the H-1B to make it something to do with the market and the current labor market.
Definitely, people. This is an interesting question the gentleman has brought with the AI coming into the field, though. Yes, I've been a lawyer before the computers were been there. When the computers came in, there was a lot of rumors that the jobs are going to be lost. Yes, the jobs were lost. I was in US in 1993 at that time. I mean, believe me, the computers were not there. It was like, I don't know, 1996, I got the computer, or 1995, I got the computer. It was a very big, huge computer. I mean, it looked like so huge. The monitor was like this. It was huge, but the front monitor was just small. And it was very slow at that point of time, and there was a lot of rumors that a lot of jobs were going to be lost. A lot of lawyers' job will be lost. A lot of people job will be lost. And yes, there are a lot of jobs that were lost because of the computers. Those people who adapted to the technology to use the technology more efficiently were able to keep the job, and those people who didn't, they lost the job. There were a lot of secretaries, there were a lot of travel agents, there were a lot of different kinds of professions that completely lost the job when the computer came in. Definitely, it's going to happen now, and it's happening right now. I definitely feel that all the people should tool themselves, whether they are lawyers, whether they are law clerks, whether they are software professionals, whether they are engineers, civil engineers, mechanical engineers. If you don't use the technology, you will be wiped out. If you don't use the technology to your advantage, you'll be wiped out. We definitely recommend all the people to upgrade their skills based on the new technologies that are coming. And we ourselves really are upgrading ourselves. If you don't, definitely you'll be wiped out.
Mahi says my EB-1A was approved in 2023 with a February 2023 priority date. When can I expect adjustment of status to be current for Indians in this category? So based on the inventory data that just came out, there are about 15,000 EB-1 India cases in front of you in line. Typically about 10,000 green cards are available each year to India in EB1, which means it might be a year and a half before your date might become current to allow you to file the 485.
Okay. Uh, Vaish Shu has this question. She filed an H4 EAD. She or he filed an H4 EAD, and they called for the biometrics. There is some criminal record on the person, though. Should I submit any documents when I go to the biometrics or when I respond to the RFE? Definitely, I would want you to consult an immigration lawyer, because if there is a criminal record, it depends on how major the criminal record is. You may have to carry the documents with you when you go to the biometrics. You may have to provide the documentation when you respond to the RFE, so that they can give the EAD in your favor. So definitely you may have to provide. Emily, what is the rule on the EAD, that even though we were able to get the SEVIS system reinstated, that you're telling that EAD is discretionary and they may not approve it? Is it applicable for the H4 EAD also, that if somebody has a criminal record, they may deny the EAD, Emily?
It is applicable for H4 EADs as well. I haven't seen that issue brought up yet in an RFE, but it absolutely could be used to deny an H4 EAD. Venkat says, how many total H-1B CAP petitions were submitted this year? Will there be a second lottery now that the filing window ended yesterday? Well, technically, it's not over yet because USCIS's wonderful online system crashed yesterday, so they extended the deadline today for people to finish up their online filing. Now, we didn't do any online filing in our office. We think it's a terrible system, so we did everything by paper, which means it's going to be weeks before we know how many petitions were actually submitted because they are still going through the intake process, and that will take some time. Last year, I feel like we didn't get the data on the actual number of petitions filed for several weeks. And so there's no way to know until it announces. And they don't announce a second lottery in advance. We just start getting random emails from the My USCIS account saying that they've conducted one. So we won't really know anything until it actually happens.
Barry says a question, if the baby is born before July 27th and the passport has not been applied until after July 27th, will that person be given citizenship status? We want to address this in a separate thing. We are inviting some other constitutional experts into that Zoom call. We want you to register yourself. There is a link that we have provided at the bottom of the video where in the MailChimp, you're going to register your email. We'll keep on updating you with the Zoom calls or any YouTube sessions that we're going to do only on the citizenship issue, because that is something very sensitive and very important to the people whose children are going to be born. So definitely we want to pay more attention. Please subscribe to that MailChimp, that is link given, and please pass on to any of those people who might be affected with this executive order. The link is provided at the bottom.
Gayatri wants to know, if I filed my H1 in normal processing 2 weeks ago, is it possible to upgrade it to premium processing now? Yes, you can, but you do need the receipt number first. So if you've not gotten your receipt notice yet, you won't be able to do the upgrade until that happens. We used to be able to get the receipt number off of the cashed check, which is usually a faster way to get the number compared to waiting for the receipt to come in snail mail. But now they've stopped putting the case number on the back of the cash check. So you're going to have to wait until it comes in the mail.
Sai Charan has an interesting question that if the Supreme Court is expected to make a decision somewhere in October, if the Supreme Court sides with Trump executive order, will it go effective in all 50 states? The answer is absolutely yes. If the Supreme Court sides with the Trump executive order, it's going to be effective in all 50 states. Absolutely all 50 states. No doubt about it. Now, what we have to see is that when the Supreme Court gives a judgment, will it say from the day the judgment has been given, going forward, those people who are getting born will not be US citizens, or will they go back to a certain date? Is the question. We don't have an answer at this point of time. But what we are sure is that if the Supreme Court sides with the executive order, though, that saying that it's completely legal, most probably from that time onwards, going forward, any children who are born will be subject to the executive order. The people born before February, between February 20th of 2025 until the Supreme Court decision is made, well, we will see how the Supreme Court is going to side with. Most probably, I'm expecting that it's going to be only going forward, but I can be wrong on that. And if you want more answers on that, we want you to subscribe to the MailChimp that we have put at the bottom of the YouTube.
Harpreet says, how much time is the perm labor certification taking? So we just got our first approval for a case that was filed in March 2024. So we're looking at 15 months about right now. That's of course not counting the amount of time it takes to get the prevailing wage and to do all of the necessary recruitment prior to filing.
As Emily has pointed out, that EB2 priority date of September 2015, this question is Saurabh Verma. It may be a long, long, long time. I mean, your September 2015 is a long, long, long time. That's a very, very long time, though. So maybe in 2030, Afterwards is what we're expecting your priority date to become current.
Deepak says, I have an approved I-140 for EB2 as a senior data engineer and wants to know if there's going to be any issues for the green card if he's promoted to an engineering manager or principal engineer. Generally, no. So USCIS does recognize normal career progression, and that likely the skills and duties of a senior data engineer are still relevant when you move into a managerial position. They have a pretty good section on AC21, whether a job is same or similar, that talks about promotions, that goes through the different things that they look at. Never had an issue with someone getting promoted like this. Even before filing the 485, especially for people from India, they're often waiting many, many years from the time they filed a labor certification till the time they actually file a 485. And they've gone through a number of different career promotions during that time. And we've never had an issue with USCIS questioning that.
Shreyas is asking this question. He's H4. Is there a chance that the H4 extension can be denied because he has a felony assault case where the case is no bail? That means case is closed because not enough evidence or the grand jury did not pursue it. We're not expecting a problem in the H4 extension because it's not a conviction. You still need to disclose that information on the H4 extension. You may be called for the biometrics, but I'm not expecting any problem for your H4 extension.
Deethi wants to know, can we file a 485 while we're on an H4 EAD? Absolutely. Even if you are the main applicant, if you are the one being sponsored, you have your own I-140 and you're in H4 EAD status, no problem at all. You can still proceed with the 485 and your spouse can be filed as the derivative, as your dependent on the 485, even if your spouse is the main applicant in the H-1B status.
YouTube has a question. It's a very odd question he has, that he got a notice from IRS asking to return 1,400, which he got in December. Is this price genuine? That seems to be very odd, the kind of question that you're asking. I want you to do one thing. If IRS is asking the money back, you can go to irs.gov and you can enroll in the program where you can see what is due from you. And I want you to pay the $1,400 online to the IRS directly, because there are a lot of fake agencies that are pretending to be IRS and asking the money. So we don't know if it's a genuine or not. If you go to irs.gov, then you'll find out if there is a $1,400 that they're telling that you're due. You can pay them online. But if some fake agencies are coming, we don't want you to pay the $1,400 to these fake agencies.
Someone says, my wife's H4 is expiring August 2025. We filed the extension back in January, and says, I know when a petition is filed, they have 240 days to stay in the US legally. Does this mean she needs to exit the US if the H4 extension is not approved by August 2025? So the 240-day rule, not applicable to H4s at all, and also not applicable to how long you can stay in the country. There is a 240-day rule. What the 240-day rule says is if you are an H-1B holder and your employer files an H-1B renewal and your I-94 expires while that renewal is pending, you can keep working for up to 240 days more based on the pending H-1B renewal. So it's about employment authorization. Now, you can remain legally in the US the entire time the extension is pending. Now, that rule is good for H-1Bs and for H-4. So because it was timely filed, she can stay beyond August 2025 the entire time that that H-4 application remains pending. She's considered to be in a period of stay authorized by the Attorney General. We refer to it as POSABAG. That is lawful presence. It's not H-4 status, but it's close to being H-4 status. She can legally stay beyond August 2025 based on the pending H-4 extension.
Amar Pali Paul Kariban. She's an H4 EAD. I have a regular job. Can I open a YouTube channel for monetization? Absolutely, you can. You can get paid in 1099 from YouTube channel, no problem. You are an H4 EAD, no problem. Can I also join a part-time job as well? Absolutely not a problem. There are some rumors where people have, I don't know what kind of people tried it. They said somebody got deported because they were having two jobs. We offered them free consultation. Nobody came in. So, absolutely, that's a lie. You can have two jobs on H4 EAD. Not a problem. Not an immigration violation. None whatsoever at all. You can have two jobs and you can have a monetized YouTube channel while you're on the H4 EAD. No problem with that.
Trailing Paw says, is there any fee required for renewing an advanced parole under the C9 category pending 485? My wife's EAD renewal was approved, but the AP application was returned due to fees. So it depends on when the 485 was filed. If it was filed before April 1st, 2024, there was no filing fee for the AP, which means renewals don't have a filing fee. But if it was filed after April 1st, 2024, then the initial AP is, I think, $630 or somewhere in that range, and you've got to pay that renewal fee every time as well.
People are asking about the priority dates, guys. If it is after January 1st of 2015, definitely it's going to be a long time. At least 5 or even 8 years from now is what we're expecting based on the load that is there. And if you are in September of 2015 or so, it's going to be even longer time. So definitely don't keep much high hopes for the priority date to become current unless there is something miraculously changes in the immigration.
Yeah, there's one other statistic I don't think I shared, and that is the number of approved I-140s that are still waiting to file the 485 because the priority date is not current. And for EB2 and EB3 India, that number is 430,000. That does not include family members. Now, yes, there are people that might have multiple I-140s, one in EB2, one in EB3, maybe multiple in EB2 because they've moved companies. But that is a very large number when we're only talking about 5,600 green cards available each year.
Can I collect rent when I'm an H1B as an investment? My wife also on the property on H480. If it's just one or two properties that you're just collecting the rent, we don't see that on a H1B. We don't see that as a problem though. Now, H4EADs, they can do whatever they want to. They can own 10 properties, have a company run as a real estate, absolutely not a problem. But for H1Bs, if you want to own 10 properties and you want to manage all 10 properties, that may become some issues. If it's one or two properties that you're just collecting the rent, we don't see any problem with it.
Asim says if the H4 I-539 is not approved with the H-1B, when they were filed together in premium processing, can the H4 travel and get the visa stamp and get the renewal that way with the H1? Yes. So for an H4 to get a visa stamp, they only need the approved H1B. They don't need the H4 I-539 to be approved as well. So your spouse would be able to go for stamping as soon as your H1 is approved. And then once they re-enter, they'll get the extended I-94 based on that new visa stamp.
I've been only married for 1 year. I got the green card, but they've given the green card for 10 years. Is it a mistake? Should I contact the USCIS? I'm assuming that you got the green card based on the family-based green card. If you got it on the family-based green cards, that definitely is a trouble. You should contact the USCIS. And if they respond, that's fine. If they don't respond, also, I want you to file the I-751, which is after within 2 years, you have to file for a permanent green card. Even though you have a permanent green card, I still want you to file the waiver for the conditional green card so that you can get a permanent green card. Don't count on the 10-year green card and sit down quietly.
All right, well, I think we're out of time for today. Thanks everyone for joining us. As usual, we'll be back on Tuesday at 5 o'clock Central Time live to give you the latest updates and answer your questions. In the meantime, if you'd like to set up a consultation with us or any of our attorneys, you can go to rnlawgroup.com.
Thank you for tuning in.